Professor Barnett's Georgetown Center for the Constitution. In 2016, he was appointed to the Ohio Advisory Committee for the U.S. Commission of Civil Rights. The University of Toledo awarded Professor Strang its Outstanding Faculty Research and Scholarship Award in 2017. Before entering academia, Professor Strang clerked on the Sixth Circuit for Chief Judge Alice Batchelder, and he was an associate at Jenner and Block in Chicago, where he practiced general and appellate litigation. Please join me in welcoming our distinguished panel.
Well, thank you, Judge Hardiman, for the introduction and the wonderful introductions of all my co-panelists as well. It's always an honor and a pleasure to address the Federalist Society Student Symposium, but I must admit that the pleasure is all the greater this year because it's being held at Georgetown Law. I'm enormously proud of our students for conceiving and organizing such a wonderful program. The Georgetown students are just one of the reasons it's so great to be a professor here. Our topic this morning is the Declaration of Independence, to which I devoted a chapter of my recent book, Our Republican Constitution. And in these remarks, I want to just make 5 points. My first point, the Constitution is not our founding document. The Declaration is. In its words, it was, quote, the unanimous declaration of the 13 United States of America, unquote, in Congress. After the founding of the Constitution, there were then 2 cracks at a form of government. First, the Articles of Confederation, and then the Constitution, and you might consider perhaps the Reconstruction Amendments to be even a third try at government. My second point, the Declaration served as a bill of indictment, quoted, quote, submitted to a candid world, unquote, alleging a long train of abuses that the British Crown and Parliament had committed against the rights of the people of the United States, and thereby legally justifying armed resistance to the Crown as something other than treason. It was viewed as abolishing the social contract with Great Britain and establishing a state of nature between 2 independent polities. In its words, by this declaration, quote, they dissolved the political bands which have connected them with another and assumed among the powers of the earth the separate and equal station to which the law of nature and nature's God entitle them. Third, the Declaration then officially identified the political theory on which the United States was founded. I stress officially because this theory was drafted by a committee, edited by the Congress as a whole, and unanimously adopted by representatives of the 13 states. And it was only after this official act that what the Declaration refers to as the, quote, form of government, unquote, was then established first by the Articles and later by the Constitution. These constitutional structures, then, were means to the ends that were identified by the Declaration. So fourth, what was the end for which these governments were then established? It's described in its 2 most famous sentences, which you all know. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. While this passage is familiar to all of you, its component parts must be separated out. So let's do that. First, all men are created equal. That's a statement of the fundamental equality of each individual person. It speaks not of groups, but of individuals. As the original draft read before it was edited, quote, all men are created equal and independent, and from that equal creation, they derive rights inherent and inalienable, unquote. The Declaration refers to certain unalienable rights. What does it mean to say a right is inalienable or unalienable? Those words mean the same thing. It means it cannot be surrendered up to the general government. In the canonical words of George Mason's draft of the Virginia Declaration of Rights, which was adopted just weeks before the Declaration, quote, all men are born equally free and independent and have certain inherent natural rights of which they cannot, by any compact, deprive or divest their posterity, unquote. This means that such rights are not and cannot be alienated by the adoption of a compact or a constitution. Next, that among these are the unalienable rights of life, liberty, and the pursuit of happiness. Notice that each of these rights belongs to the people as individuals. They are not group rights. They are not collective rights. They are the individual rights of we the people, each and every one. And now we turn to what may be the most important sentence identifying the political theory of the founding. Quote, that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. The expressly stated end of government is to secure the individual rights named in the preceding sentence. Excuse me. In short, governments that are instituted among men are the means. Securing the individual rights of every person is the end against which such all governments are to be judged. Sorry about this. Because of the failure of the British government to fulfill, well, actually, I just skipped ahead in the course of choking in front of you. Because of the failure of the British government to fulfill this political function, that is the securing of the rights of each one of us, these united colonies are, and of right ought to be, free and independent states, and that all political connection between them and the state of Great Britain is and ought to be totally dissolved. Excuse me. I've been a professor for 35 years. I was a trial lawyer before that, and this has never happened to me before. I'm getting over a cold that's lingered on. So the political theory announced in the Declaration of Independence can be summed up in a single sentence. First come rights, and then comes government. First comes rights, and then comes government. Now, this is not, as some would say, a libertarian theory of government. The Declaration of Independence shows it to be the American theory of government. According to the American theory of government, the rights of individuals do not originate with any government, but pre-exist its formation. According to the American theory of government, the protection of these rights is both the purpose and first duty of government. According to the American theory of government, at least some of these rights are so fundamental that they are inalienable, meaning that they are so intimately connected to one's nature as a human being that they cannot be transferred to another, even if one consents to do so. According to the American theory of government, because these rights are inalienable, even after a government is formed, they provide a standard by which its performance is measured, and in extreme cases, its systemic violation of or failure to protect these rights can justify its alteration and abolition. Or in the words of the Declaration, quote, whenever any form of government becomes destructive of these ends, that is, the securing of these rights, it is the right of the people to alter or abolish it and to institute new government, laying its foundation on such principles and organizing its powers in such form as to them shall seem most likely to affect their safety and happiness. So my fifth and final point concerns the passage, quote, deriving their just powers from the consent of the governed. Does this entail that the inalienable rights of we the people as individuals can be altered or abolished by popularly elected legislatures representing the consent of the governed? Hardly. Representative government is merely one means among several to the ends of protecting what the Ninth Amendment refers to as the rights retained by the people, a subject that came up last night. neither by acts of legislation nor by the Constitution itself may the people divest their posterity of these inalienable rights to life, liberty, and the pursuit of happiness. And according to this passage, governments may exercise not all powers, not unlimited powers, but only their just powers. A just power is one that is within the competence of a legitimate government, which the Declaration defines as one that secures the inalienable natural rights of we the people, each and every one. So this passage is not about popular governance superseding pre-existing individual rights. It is about which government is to govern a polity. Will it be the government of Great Britain or the governments of the United States? Will it be a state government, a national government, or some combination of state and national governments? It is this question that the Declaration maintains is to be decided by the consent of the governed. I apologize for this. Yeah, would have been helpful about 10 minutes ago. Well, I won't choke during the other people's talk this way. As Lee Strang will contend in his remarks, the original public meaning of the text of the Declaration of Independence is independent of the original public meaning of the Constitution itself. But the Constitution does not justify itself. To be legitimate, it must be consistent with political principles that are capable of justifying it. The fundamental principles that the founders thought underlie the Constitution were not shrouded in mystery or to be found in the writings of Locke, Montesquieu, or Machiavelli. The American theory of government was officially identified and adopted in the Declaration of Independence. Thank you.
Greetings. It's an honor for me also to be here. At least on this panel, I'm the only non-law professor, so I may sound different to most of you than the others. I hope I won't break into
Whatever.
paroxysms of coughing. But I'm here to talk on the topic of the relation between the Declaration and the Constitution, as are the others. This is a question which has been often raised and quite variously answered over the course of American history. I can think of at least 5 or 6 or maybe even 7 different answers that have been given to this question over the course of our history, I do not have time, however, to talk about all of those. So I'm only going to limit myself to 3 such answers that have been given, 3 that I think are somewhat polar to each other and also among the most frequent of the answers that have been given. So the first position I'm going to speak about is what I'm going to call the fusionist position, which holds that the Declaration is, in effect, we could say, a part of the Constitution itself. And because there are a number of variants of this fusionist thesis, this one gives us answers which have some, in some cases, or less, in other cases, legal authority when looking at the Constitution. The second position I'm going to talk about is rejectionist, in that it holds that there was a very conscious effort to distance the Constitution from the Declaration. And on this reading, the Declaration has no or very little legal authority in constitutional law. Third is what we might call the apple of gold theory, which is named after a famous meditation by Abraham Lincoln on a biblical passage. This one lies between the two previously cited theories, in that under it, the Declaration retains some authority, some significant meaning in constitutional interpretation, but is not so intimately connected to the Constitution as the fusionist theory holds. I'm going to begin with the rejectionists. In various guises, these have been quite influential at different times in American history. The first rejectionists, I think it's fair to say, were the anti-federalists, that is, the people who opposed the adoption of the Constitution. Many of them believed that the Constitution represented a conscious turn away from the thoughts and the aspirations of the Revolution, represented at its peak by the Declaration. The Declaration declared, they pointed out, that the individual colonies were to be free and independent states, with an emphasis on the plural, states, which the Anti-Federalists thought was consistent with the kind of politics the makers of the Revolution hoped to institute, a kind of governance we might call short-leash republicanism, where the governors were to be as alike the governed as possible and to be held on as short a leash by the governed as possible, under as much control by the governed as possible. The Anti-Federalists believed that this mode of government was most likely to produce the kind of governance in accord with the principles of the Declaration, government which is close to the people and thus thus consistent with the consent of the governed as decreed in the Declaration. Likewise, it would be closer to the principle of the equality of all people as announced in the principle of created equal. And perhaps most importantly, and I know Professor Barnett's heart will go pitter-patter here, of securing the inalienable rights of the equal individuals. So the Anti-Federalists saw the Federalists and their Constitution to be a retreat from the aims and aspirations of the Revolution and from the institutional devices and structure favored by the revolutionary generation, most famously the small republic. The Anti-Federalists tended to interpret the Constitution's nationalism, its commitment to a large republic, and the, at best, long leash approach to institutional design to be the result of a turn against the democracy and the strong commitment to rights that they, the Anti-Federalists, favored. They saw the Constitution to be a rejection of the Declaration, of its principles and political implications, and in turn they rejected or sought to greatly modify the Constitution as proposed. Now, recognizable heirs of the Anti-Federalists have popped up from time to time during American history, one very notable instance being during the Progressive era, most famously, but not by any means exclusively, in the work of Charles Beard. Beard and his fellows repeated much of the Anti-Federalist analysis of the movement for a new Constitution. They saw it as an oligarchic coup against the more democratic Declaration that led them, as it led the Anti-Federalists, to be skeptical and negative about the Constitution. Thus, we see a progressive like Woodrow Wilson encouraging or discouraging discouraging us from abiding by the Constitution we have and moving towards something more like a parliamentary system. Anti-Federalists, the Anti-Federalists, and I'll get this straight. I have a different problem from Mr. Barnett. My notes I can't read. That's my all right. However, the Anti-Federalists, unlike the progressives, were quite, the progressives, unlike the Anti-Federalists, were quite ambiguous about the Declaration of Independence itself. They appreciated its democratic aspects, but they, for a variety of reasons, rejected its groundings in natural law and natural rights. As opposed to the Anti-Federalists, it would be only half correct to say that they sought to place the Declaration in a central position in the constitutional order. In general, the progressives and their heirs were committed to very limited forms of judicial review, putting much more weight on the democratic voice of the sovereign people, and they were restraintists, we might say, but not originalists. The Federalists, to the contrary, saw their Constitution to be harmonious with the Declaration, to be a necessary shift away from the kind of political institutions and structures that the Anti-Federalists favored in order to build a government capable of competently supplying those aims that the Declaration announced, in particular, protecting the rights of the people. The Federalists had to recognize, though, that their Constitution deviated in some important ways from the Declaration with regard to slavery, most obviously. And therefore, the full-blown, what I'm calling fusionist position, did not take shape in Federalist thought. That fusionist position came to full fruition during the debate over slavery. So the most representative adherents of the fusionist theory appeared within the abolitionist movement. A very fine example of the constitutional fusionist theory appeared in a case concerning a captured slave ship called the Amistad, having been made into a movie by, I think, one of those directors. Spielberg, yeah, that's it. That's his name, yeah. Obscure, kind of one of those obscure guys. This case involved, if you didn't see the film, this involved a slave uprising on a slave ship in which the uprose slaves killed all of the whites on board the ship except two who they kept alive to take them back to Africa from where they believed they had been illegally kidnapped. However, on the way back to Africa, they were found by a U.S. brig, surveying brig, off the coast of Long Island. It isn't quite clear these two white guys were driving them actually back to where they wanted to go. But they were picked up by this U.S. ship, and that set the stage for a very complex litigation, a salvage litigation over who, if anybody, owned these slaves. One set of claimants who were supported by the Attorney General of the United States based their case in part on a treaty dating from 1795 between the United States and Spain. That treaty provided that, and this is a quotation, all ships and merchandise of what nature soever, which shall be rescued out of the hands of any pirates or robbers, shall be restored entire to the true proprietors. And two of these claimants had papers issued in Cuba, at that time a slave state, attesting that they were the owners of the slaves on the ship. And they wanted the U.S. to restore to them their property as provided for under this treaty. The alleged slaves, though, were also parties to this case, claiming that they were free under the terms of another treaty dating from 1817. And the attorney for the Africans made a quintessential statement of this fusionist theory. He began by raising the question, can the government established on the principles of the revolution as stated in the Declaration of Independence become a party to proceedings for the enslaving of human beings? He answered his own question by asserting that our government, based on the Declaration, is not authorized to commit such an atrocity against human rights. As he said, we are neither duty-bound nor allowed even to give effect to the slave trade laws of other countries. To do so is to violate the rights of man. So it is clear that he's treating the Declaration as an integral part of the Constitution, its principles having even the power to override provisions of the constitutional text or, in this case, of a treaty. The third theory that I wish to discuss also achieved classic formulation during the debate over slavery. Alluding to a passage in the book of Proverbs, which goes, "A word fitly spoken is like an apple of gold in a picture of silver." Abraham Lincoln said of the Declaration and the Constitution, "The Declaration is the word fitly spoken, which has proved an apple of gold to us. The Union and the Constitution are the picture of silver, subsequently framed around it. The picture was made not to conceal or to destroy the apple, but to adorn and preserve it. The picture was made for the apple, that is the Constitution, for the Declaration, and not the apple for the picture." And a shorthand way to state the apple of gold thesis is to say that the Constitution is to serve as a means to achieve the ends and principles of legitimacy set out in the Declaration. This theory also understands the relation between the two to be intimate, but not so intimate as the fusionists hold. As we saw at its most extreme, the fusionist theory holds that the Declaration trumps the Constitution. As effectuated by Lincoln himself, this is not the case with the apple of gold position. As he said in his response to the Dred Scott decision, the following: "I think the authors of the Declaration did not intend to declare all men equal in all respects. They defined with tolerable distinctness in which respects they did consider all men created equal, equal in certain inalienable rights. This they said, and this they meant. They did not mean to assert the obvious untruth that all men were then actually enjoying that quality, nor yet to say that they were about to confer it immediately upon them. They meant simply to declare the right so that the enforcement of it might follow as fast as circumstances should permit. In a word, Lincoln recognizes that the Constitution falls short of the Declaration in many ways. That slavery is contrary to the Declaration does not, however, negate the fact that it receives some protections in the Constitution, protections that he believed required recognition in constitutional interpretation. Thus, he frequently clashed with the fusionist abolitionists when he pledged as president to enforce the Fugitive Slave Act and clause of the Constitution, despite the injustice of slavery. Rather than a trump card, the apple of gold theory declares the Declaration to be, as he put it, a standard maxim for a free society, which should be familiar to all and revered by all, constantly looked to, constantly labored for, and even though never perfectly attained, constantly approximated, and thereby constantly spreading and deepening its influence and augmenting the happiness and the value of life to all people of all colors, of all classes, everywhere. It is a political and a moral standard and goal, but not a law. That's the way Lincoln sees the relation. Having now briefly sketched these three theories, I think we're left with two questions. Which, if any of them, is the correct theory of the relation between the two documents? And how do we go about answering such a question as that? Thank you.
Thank you very much, Judge Hardiman, for your kind introduction. In my capacity as Associate Dean, I want to take the opportunity to welcome all of you to Georgetown and to thank and congratulate Ethan and Dorina and the other organizers for this wonderful event that they have put together. It's a pleasure for me to be able to participate. In listening to Judge Hardiman's introduction, it occurred to me that I need to update my biography on the website because it sounds like I only work in cognitive science and philosophy. I do actually also write and teach in the area of constitutional law. For several years, I've taught a seminar here with Dean William Traynor on the drafting and ratification of the Constitution, and I'm going to draw on some of that work today. So whenever the relationship between the Declaration of Independence and the Constitution arises, most of the attention naturally gravitates to the principle of equality and natural rights background of the Declaration, which Randy Barnett and Michael Zuckert have discussed, and which have played such an important role in American history. The question then becomes whether and to what extent the Constitution embodies these background principles. In my remarks today, I'd like to focus on a different and less familiar connection between these two foundational documents, which bears on the issue of government powers rather than individual rights. I'll make three main points which might surprise you. I'll first simply state them without much elaboration or qualification, and then I'll circle back and say a few words of clarification about each of them. So here are the 3 points. First, some of the most influential founders considered the Declaration of Independence to be, in effect, the first Constitution of the United States, which not only declared the existence of a new nation, but also vested the United States with all of the express and implied authority of any other nation, including the, quote, full power to levy war, conclude peace, contract alliances, establish commerce, and to do all other acts and things which independent states may of right do. Second, these same founders celebrated the Constitution precisely because it marked a return to the broad conception of implied national powers vested in the United States by the Declaration, which the Articles of Confederation had sought to deny the national government. Third and finally, when it came time to draft the Constitution, the principal framers of that document turned back to the Declaration for inspiration. The specific language on which they relied was its reference to all other acts and things which independent states may of right do. This language had directly inspired the all other powers provisions, or sweeping clauses, that one finds in several early state constitutions, such as the Delaware, Pennsylvania, and Vermont state constitutions. And it also served as a template for the all other powers provision of the Necessary and Proper Clause, which James Wilson drafted for the Committee of Detail. So my 3 points can be compressed into a single sentence. The Declaration was effectively the first Constitution of the United States, which vested the United States with implied national powers and which later inspired one of the key provisions of the Necessary and Proper Clause. That's the main takeaway of my remarks. Let me now try to unpack each of its parts and say a bit more about each of them. So let's begin with the idea that the Declaration was, in effect, the first Constitution of the United States, which vested the United States with all of the power of any other nation, including the right to do all acts and things which any other nation might do. What should we make of this language in the final paragraph of the Declaration? A conventional reading of this passage assumes that the enumerated powers to which it refers, that is, the power to levy war, conclude peace, contract alliances, establish commerce, and so forth, that those powers were declared to belong to each state individually. On this familiar view, the Declaration produced 13 independent nations, each of which was a free and independent state, and each of which possessed these powers. At the Constitutional Convention, Maryland's Luther Martin endorsed this view when he claimed that the people of America preferred the establishment of themselves into 13 separate sovereignties instead of incorporating themselves into one. And Martin added that the separation from Great Britain placed the 13 states in a state of nature towards one another, and they would have remained in that state but for the Articles of Confederation. Now, Martin's view has a certain appeal and plausibility, but I want to call your attention to the fact that many of the framers, many of the most important and influential framers, roundly rejected this interpretation. So James Wilson, for example, at the Constitutional Convention, stood and read from the Declaration of Independence and argued that the proper way to interpret it was that it implied that the states had declared their independence and possessed those enumerated powers, quote, not individually but unitedly, that is, in their collective corporate capacity. Alexander Hamilton agreed with Wilson and disputed Martin's claim that the Declaration had placed the states in a state of nature. And Rufus King reached similar conclusions by arguing that the individual states had never been sovereigns in the sense contended for by Martin. King pointed out that the states lacked many of the sovereign powers to which the Declaration refers. They couldn't make war or peace or alliances or treaties. As political beings, he said, the states were dumb, for they could not speak to any foreign sovereign whatever. They were also deaf because they could not hear any propositions from these foreign governments. So who was right in this debate? It's a long-standing debate. It's still with us in some respects. My own view is that on balance, the nationalists had the stronger argument. Without trying to settle the matter here, let me call your attention to several of the points in their favor. And this is just repeating arguments that have been made over the course of our history by people like Hamilton, Joseph Story, Abraham Lincoln, and historians like Richard Morris and others. A few points to think about. First, the national government of the United States existed and was in operation before the formation of the individual states. The nation preceded the states. The delegates to the First and Second Continental Congresses were generally selected by the people of the colonies, not by the colonial legislatures. It was these Congresses that issued authorizations to the people of the colonies to organize new state governments in 1775 and 1776, beginning with New Hampshire and South Carolina, and then followed by the other states. During this critical period, Congress exercised implied national powers of a sweeping sort, as Hamilton and others frequently pointed out. So, for example, it commissioned a Continental Army and placed George Washington at its head. It borrowed money on behalf of the United States. It defined treason against the United States. It issued national passports in the name of the United States. Throughout the Revolutionary War, Congress's right to conduct foreign affairs, defense, diplomacy, the negotiation of treaties, went unchallenged by the states. The Treaty of Peace with Great Britain was ratified solely by Congress on behalf of the United States, despite the fact that Article 9 of the Articles of Confederation held that, quote, no state shall be deprived of territory for the benefit of the United States. The Treaty of Peace adjusted the boundaries of 8 states without their affirmative consent. And there are many other similar examples of implied national powers that were exercised during this period. So what justified the exercise of these implied powers? Well, the classical argument was given by James Wilson in his defense of the Confederation Congress's authority to charter the Bank of North America. And before turning to that argument, let me say a few words about Wilson, because he's not as well known as he should be. By any measure, he's one of the most remarkable figures in the history of American law, one of 8 immigrants to America to sign the Constitution. He's the only founder to sign both the Constitution and the Declaration of Independence, and to serve on the United States Supreme Court. He wrote the first complete draft of the Constitution, and in that capacity, he was primarily responsible for the precise language of many of its most significant clauses and phrases, including the vesting clauses, the necessary and proper clause, the supremacy clause, and the majestic opening words of the preamble, we the people. One of the best lawyers and legal minds of his generation, Wilson has also been called the most democratic founder because of his unwavering support for popular sovereignty and the principle of one person, one vote. Now, when Wilson put his mind to defending the constitutionality of a national bank under the Articles of Confederation, he faced long odds. The argument that Congress lacked the authority to charter such a bank was simple and straightforward. First, no such power was expressly given by the Articles of Confederation. Second, an implied power to charter a bank was apparently foreclosed by Article 2, which limited Congress to expressly delegated powers and reserved all other powers to the states. Wilson, however, denied this conclusion, offering an ingenious argument that sharply narrowed the force of Article 2. The power to charter a national bank, he argued, was not a power possessed by any individual state. Thus, it was not a power that the states could delegate in the first place. Rather, the power to charter a national bank was an implied power that derives from the union of the individual states. It was a national power for national purposes, and one of those other acts or things to which the Declaration referred in 1776. So Wilson wrote, and I'll just quote some of this language because it is so important and has been so influential in the further development of American constitutional law. The United States have general rights, general powers, and general obligations not derived from any particular states, nor from all the particular states taken separately, but resulting from the union of the whole. To many purposes, the United States are to be considered as one undivided, independent nation, and as possessed of all the rights and powers and properties by the law of nations incident to such. Whenever an object occurs to the direction of which no particular state is competent, the management of it must of necessity belong to the United States. The Act of Independence, and so he refers now to the Declaration of Independence. This is in 1785 when he made this argument publicly in a pamphlet that was published. The Act of Independence was made before the Articles of Confederation, Wilson argued. This act declares that these united colonies, not enumerating them separately, are free and independent states, and that as free and independent states, they have the full power to do all acts and things which independent states may of right do. He then concludes by arguing that the Confederation was not intended to weaken or abridge the powers and rights to which the United States were previously entitled. It was not intended to transfer any of those powers or rights to the particular states or any of them. If, therefore, the power now in question, the power to charter a national bank, was vested in the United States before the Confederation, it continues to vest in them still. The Confederation clothed the United States with many, though perhaps not with sufficient powers, but of none did it disrobe them. This is a remarkable argument. There are many remarkable features of this argument. Among other things, it anticipates many important cases in American constitutional law, including doctrines articulated in Chisholm against Georgia, Fletcher against Peck, McCulloch against Maryland, Dartmouth College against Woodward, Cohen's against Virginia, Missouri against Holland, and United States against Curtis Wright. For our purposes, 2 points deserve emphasis. First, it's notable that Wilson decides whether the United States is authorized to charter a national bank by asking whether it could do so before the Articles of Confederation. He then argues that if the power existed then, it remains vested in the United States still, because the Articles did not deprive the United States of any of its powers. Consider the implications of that type of argument for our understanding of the 10th Amendment, for example. Second, Wilson argued that the power to incorporate a bank is an implied power vested in the government of the United States by the Declaration. And the implications of this argument for how we might understand the, quote, powers vested by this Constitution in the government of the United States, to which the necessary and proper clause refers, are likewise profound. One final point about Wilson's bank argument that I'd like to call your attention to. In these passages, Wilson emphasizes that implied national powers are vested in the United States in their collective capacity, in the Union, in other words, rather than in its individual members. And to clarify this point, he adapts a metaphor from the Swiss jurist Burle-Marquis. And the metaphor is harmony. Harmony, Wilson says, in effect, is a musical property that no one individual voice can produce on its own. It requires the combination of two or more voices. Accordingly, harmony is an emergent property that resides at the group level, not at the level of one or more individuals. And in a similar fashion, Wilson argues, certain national powers lie beyond the competence of individual states. They're vested and can only vest in the government of the United States, conceived as a composite whole. Let me turn now to the last part of my remarks and very briefly explain how all these ideas about implied powers and the Declaration of Independence influence the drafting of the Constitution. The key point here to recognize is that when Wilson drafted the necessary and proper clause, he sought to declare and incorporate into the Constitution the doctrines of implied and inherent powers that he and the leading nationalists of the period, people like Hamilton, Robert Morris, Gouverneur Morris, and others, had located in the Declaration and had relied on throughout the critical period to justify the exercise of the authority of the United States over the war effort, public finance, foreign affairs, and Western lands. Here it's crucial to pay close attention to the constitutional text and what Hamilton called the peculiar comprehensiveness of the necessary and proper clause. In addition to granting Congress the instrumental power to carry into effect its enumerated powers, that clause also gives Congress the express power to make, quote, all laws which shall be necessary and proper for carrying into execution all other powers vested by this Constitution in the government of the United States or in any department or officer thereof. Unless one of the latter provisions is treated as surplusage, this text implies that the Constitution vests powers in the government of the United States that are not merely identical or coextensive with the powers it vests in the departments or officers of the United States. Because these additional government powers are not specified in the Constitution, they must be understood to be implied or unenumerated powers. Much like the existence of unenumerated rights in the Ninth Amendment, then, the existence of implied or unenumerated powers is explicitly recognized by the text of the Constitution. And Wilson, of course, was instrumental in the origin of both of these provisions, the Ninth Amendment and the Necessary and Proper Clause, both of which reflect deep features of his jurisprudence. He firmly believed that the limits of enumeration applied to both rights and powers. All of us are familiar with the argument with respect to the Ninth Amendment. It's impossible to enumerate all the natural rights that individuals possess, so it's dangerous to enumerate them and necessary to indicate that there are other rights that should not be disparaged. That's true. Wilson believed the same thing about government powers, and he said so at the Constitutional Convention. It would be impossible to enumerate the powers which the federal legislature ought to have, and he drafted the Necessary and Proper Clause to recognize and accommodate that fact. Wilson's reference to, quote, all other powers in the Necessary and Proper Clause was inspired by the Declaration's all other acts and things provision, and by similar all other powers provisions in the several state constitutions to which I referred. There was a term that the founding generation used for this type of clause, a sweeping clause. The essential function of a sweeping clause is to cancel the implication that a given list of items is exhaustive. And the and all other language is the most common formula for doing so, both then and now. Unlike the Articles of Confederation, then, both the Declaration of Independence and the Constitution contain a list of enumerated powers followed by a sweeping clause of the and all other variety. The fact that both of these foundational documents contain a sweeping clause is one of the clearest textual and conceptual links between them. The connection goes to the heart of how the framers understood American nationalism and the implied powers vested in the government of the United States. And finally, it may also reflect the wisdom of John Adams's famous observation that American constitutionalism was a game of leapfrog. The first leap, however, was not the Articles of Confederation, but rather the Declaration of Independence itself. Thank you.
Thank you very much, Federalist Society, for sponsoring and hosting this event and this panel. I've already learned a lot from each of my panelists and things that I didn't anticipate, even having read their prior scholarship. I appreciated Judge Hardiman's remarks about the fantastic story of the Declaration's survival, and it kind of reminded me of a less fantastic anecdote where when I was here at Georgetown, I took some of the Strang kids over to the National Archives to see the Constitution and the Declaration. And as we were walking in, there was a group of younger people who were speaking with a British accent. So I said to my kids, hey, let's go over and see what they're saying. And I assumed they'd be talking about the Constitution and how elegant it is compared to the British unwritten Constitution. Or I thought they'd talk about the Declaration and how, boy, those colonists made a bad decision over 200 years ago. Or at least they'd talk about Shakespeare or Jane Austen. But what they were talking about was Facebook posts back in the UK. So it was very disheartening. The title of my remarks this afternoon is The Declaration of Independence, No Special Role in Constitutional Interpretation. My arguments are based upon 2 articles I published and some other unpublished work that I'm currently working through. I argue this morning that the Declaration is a beautifully written document, that it's a potent symbol of our nation's birth and founding principles, but that it should not and does not play a unique role in constitutional interpretation. Instead, the Declaration is one source among many of the Constitution's original meaning. And I think you heard many of the panelists actually giving evidence of that today regarding what they perceived as the impact either on a particular clause, the necessary and proper clause, or on the Constitution's structure overall or its goals overall, supporting the claim I'm making now. Frankly, this isn't what I expected when I began my research into the Declaration almost a decade ago. Instead, like most Americans today, I assumed that the framers and ratifiers either viewed the Declaration as of a piece with the Constitution or at least as the interpretive key to the Constitution. And I think I learned this thinking back from going to political events with my parents, or I went to pro-life events with my parents as a youngster, and the speakers would make arguments like this. The Declaration requires us to interpret the 14th Amendment's person to include unborn human beings. And so I assumed that that view was consistent with what went on in the framing and ratification either of the original Constitution or the Reconstruction Amendments. And today I'm sharing with you the reasons why I changed my mind on that. And I'm only able to talk for a couple of minutes, and so I'm giving you just the bare sketch of the arguments that I'm presenting. So my thesis is that the Declaration is not the unique interpretive key to the Constitution, and instead it's one source of the original meaning. And I'll make two arguments to support that. The first is a claim internal to originalism, and the second is a historical claim. So first, and this is just a summary of the argument that I'll give in detail in a moment, theoretically, I argue that mainline originalist theory shows that there's no analytical space within the theory for the Declaration to play a special role in constitutional interpretation. Second, and historically, I'll summarize three moves to show that the Declaration does not play a unique interpretive role. My arguments today presume that originalism is the correct interpretive theory. I make that assumption because I think that it is the correct interpretive theory, and also because most declarationists, that is, scholars who argue in favor of the Declaration playing more of a role than what I'm arguing, adhere to this premise, although not all. So first and theoretically, mainline originalist theory shows that there's no analytical space within the theory for the Declaration to play a unique role. Public meaning originalism identifies the text's public meaning when it was ratified as its authoritative meaning. And originalists have identified a multi-step process to identify the original meaning, and none of those processes, none of those steps privileges the Declaration. So the first step that an originalist will do is to look for the conventional meaning of the text in the period of ratification. And this is the standard usage of that text at the time of ratification. For example, if we're looking for the conventional meaning of the word religion, we look to how did Americans use that word in 1791. The second step is an interpreter will identify the text's semantic meaning by placing that text, that conventional meaning, in the context of the Constitution and applying the rules of grammar and syntax. And this involves identifying how the words are put together in clauses and sentences along with their punctuation, which may modify the text's conventional meaning. For example, the word religion doesn't appear by itself in the Constitution or the First Amendment. It's arguably a part of at least one clause, or some people argue two clauses, including, for example, the phrase, the free exercise of religion. And this phrase, the free exercise, could impact the conventional meaning of religion. Third, an interpreter takes into account the context of when the Constitution was ratified. And this context is the contemporary, publicly available context in which the Constitution's text was drafted and debated. So, for example, the fact that when the free exercise of religion was adopted in 1791, most states conditioned religious exercise on, for example, quote, not being inconsistent with the peace or safety of the state, as New York's 1777 Constitution provided. This context may suggest that the phrase, the free exercise of religion, carried that connotation and that limitation into its meaning. So the Declaration is not a privileged element of any of these three steps. For example, one would not prioritize the Declaration to ascertain the conventional meaning of a word. Instead, under current originalist theory, the Declaration is simply one piece of evidence, potentially at steps 1, or what I described as step 3, the conventional meaning or the framing and ratification context. Now, this theoretical point then makes an historical question of the extent to which the Declaration actually influenced the creation and interpretation of the Constitution. And so that's my second move. Second, and historically, I'll describe how three distinct pieces of historical evidence show that the Declaration did not play a unique role in the creation or interpretation of the Constitution. First, the framers and ratifiers did not use the Declaration as a special key to the creation or interpretation of the Constitution. In my research on the period of the framing and ratification, I uncovered very few statements regarding the Declaration, and none arguing or assuming that the Declaration would play a unique role. Instead, the framers and ratifiers used the Declaration for three primary purposes. First, its practical impact, and we actually heard this from Professor Mikhail a little bit earlier, as the creator and point of independence from Great Britain. For example, in the Constitutional Convention, Rufus King and Luther Martin debated the Declaration's impact. Was it, as King stated, that the states became one collective entity, or was it, as Martin argued, that each of the 13 states became independent states? Second, the Declaration was used to bolster an argument for or against the Constitution's merits when the merits of the provision were agreed upon by the debate proponents. For example, in the Pennsylvania Ratification Convention, John Smiley, an opponent of ratification, argued that a Bill of Rights was indispensable because it established the parameters for those in power. And to support his position, he quoted the Declaration for the proposition that America should secure its rights through a Bill of Rights, or else the right to abolish government identified in the Declaration is, quote, mere sound or without substance. Both sides of the debate over the Bill of Rights agreed that the Declaration was not the interpretive key, but used as a tool to argue for or against an inclusion of a Bill of Rights. Third, the framers and ratifiers used the Declaration for rhetorical impact. For example, the Federalist Papers, arguably the most comprehensive argument at the time in favor of ratification, and therefore on its meeting, cited the Declaration twice, and both times for the unexceptionable proposition that it's legitimate to change one's form of government. And this consensus, I think, is the consensus of most historians. So Pauline Maier, for example, concluded, quote, participants in the extensive debates over the creation and ratification of the Constitution mentioned the Declaration very infrequently, and then generally cited to its assertion of the people's right to abolish or alter their governments and to found new ones. So in sum, the historical evidence shows that the Declaration was one source among many of the Constitution's meaning. My second historical argument was presaged by Dr. Zuckert regarding the Declaration's inconsistency with the Constitution's text. And Dr. Zuckert identified slavery as being the most prominent example, and I won't belabor that point, other than to say that when you looked at the Reconstruction period, only relatively few, relatively radical abolitionists argued that the Constitution, without the necessity of amendment, outlawed slavery. So, for example, following and during the Civil War, few abolitionists argued that the Constitution, properly interpreted in light of the Declaration, abolished slavery without amendment. And even those who held that belief, in other words, who held the belief that the Constitution didn't need to be amended to abolish slavery, recognized that their views were idiosyncratic. And so Charles Sumner from Massachusetts, who was a Declarationist, recognized that his views were a minority position and therefore worked to secure passage of statutes and constitutional amendments to secure them. So in sum, the Declaration's inconsistency with the text shows that it can't be the interpretive key. Third, in times of subsequent national moral crisis, Americans turn to the Declaration to support their out-of-the-mainstream constitutional interpretations. In the immediate aftermath of the Revolution, the Declaration fell out of the public's consciousness, only to be periodically resurrected by reform movements that have used it for a variety of purposes. Social movements throughout the American history, including and beginning in the 1820s with the abolitionists, utilized the Declaration to support their unconventional constitutional visions. These included, in addition to the abolitionists, suffragettes in the mid to late 19th century, the modern civil rights movement, and most recently the pro-life movement. What this phenomenon shows, I think, is that appeals to the Declaration are motivated by the movement's goals of political, social, and legal change, and not historical claims about what the Constitution, properly interpreted, actually means. In other words, this shows that appeals to the Declaration originate extrinsically to the Constitution and are not intrinsic to the Constitution or to its history. Let me close with a couple of caveats. So my arguments today dealt with constitutional interpretation, interpreting the Constitution's original meaning. There's another facet of originalist theory that has developed over the last 10 to 15 years. Professor Barnett pioneered this work on a distinction between interpretation and construction. And construction is when the Constitution's original meaning is at least when the Constitution's original meaning is underdetermined, where it doesn't provide one right answer. And a declarationist could argue that in the so-called construction zone, where the original meaning isn't determinate, the relevant interpreter should rely on the Declaration to construe, to create constitutional meaning. And in my initial remarks, I'm not addressing that move. And second, I'm not addressing Reconstruction as well. My arguments focused on the original Constitution, and a declarationist could argue, and I think with some plausibility, that the Declaration was central to the creation at least, and maybe the interpretation of the Reconstruction amendments. And I'm not going to address that either in my initial remarks. So in sum, I've argued that the proper role of the Declaration of Independence in constitutional interpretation is one source of the original meaning. That's an important role, but it's one limited and more limited than what many others have argued. Thank you very much.
All right. I'd like to invite folks to line up to ask questions. I want to make sure there's time for that since we started a little bit late. And while people are lining up, invite the panelists to comment on what they heard. Professor Barnett, do you want to start? Or
Sure. Hopefully, I'll be able to do this. I just want to commend the other panelists for their contributions. I thought they were great. And as always, my colleague John Mikhail's comments were provocative and exquisitely reasoned and well-researched. He is a formidable constitutional scholar who evaluates original meaning and the evidence about original meaning in good faith and in enormous detail. He has a very challenging thesis, and I am not in a position today to refute it. Some of this requires us to rehearse some arguments that we've had about the necessary and proper clause. So I'll just say this. His argument for implied powers depends on the idea that the necessary and proper clause is a power that was granted to the federal government, which it is, and therefore its text implies implied powers. Or actually, he says this text expressly allows for implied powers. And to some extent, of course, everyone agrees with that, because everyone agrees that there are at least incidental powers that the necessary and proper clause allows the federal government to exercise, which are not expressly stated in the foregoing powers or elsewhere in the Constitution. So we all agree with that. So then the question is, are there inherent powers or extra implied powers of the kinds that he was describing in his talk? And there is one part of the necessary and proper clause that he did actually quote later, but when he was making this exact point, he left out, which, we've been around this many times, he and I, and so I know he's actually not concealing it, but I would like to emphasize this point. And that is, it says, to make all laws which shall be necessary and proper for carrying into execution the foregoing powers, the enumerated powers, and all other powers vested by this Constitution in the government of the United States, or in any department or officer thereof. So I don't think this is an expressed affirmation of implied powers not vested by this Constitution. You have to then be a little bit creative about what it means for the Constitution to have vested a power. And if you're relying on the necessary and proper clause itself for that claim, and then the necessary and proper clause itself refers to the Constitution, meaning, in my view, the written Constitution. So you would then need to go back to the written Constitution and see where in the written Constitution there are these implied powers other than the necessary and proper clause, because that's what the necessary and proper clause expressly says, by this Constitution. Now, John has answers to this question. Some of them are based on the preamble of the Constitution and what the appropriate role of the preamble is. This is a very long and detailed debate that we could have about this. But I just want to point out that, in my view at least, the Declaration does state the fundamental principles, the American theory the American political theory, but then those principles have to be implemented. And the U.S. Constitution is the way it was implemented, and it was implemented in writing, and it was put in writing for a reason. And it was widely accepted that this was a government of limited powers, enumerated powers and limited powers. And John's reading of this, I think, would be in tension, at least, with that widespread and widely held assumption.
great. Let's hear from Professor Mikhail in response.
Sure, thank you. Let me start by thanking Randy for his kind remarks. And as I hope was implicit in my remarks, I'm a big fan of Randy's work, particularly his work on the Ninth Amendment, which I think is generally spot on and is part of my own thinking about the Constitution. So just on the particular points that he raised, let me briefly reply. I think he's quite right that the language of the necessary and proper clause, all of it, has to be taken very seriously, including the reference to powers vested by this Constitution. So one might think, for example, that that language precludes any appeal to inherent powers of the government. Rather, it suggests that the powers have to be vested by the Constitution. And the 10th Amendment serves a similar function when it limits the government's powers to those which are delegated to the United States, delegated by the Constitution. So that's, I think, a plausible reading. On the other hand, it's a big question how we understand how documents like the Constitution vest powers or delegate powers to the national government. And a couple of points to bear in mind here. Many of the founders understood the Constitution to be a corporate charter. They refer to it as such, so these are people like Hamilton, Wilson, and later John Marshall, some of the very best lawyers among the founding generation. And it was well understood in this period that corporate charters, the act of incorporation, could imply powers to the corporation that were not explicitly enumerated. Blackstone talks about this in his commentaries. Wilson talks about this in his lectures on law. So one way to think about this is that they understood that the United States was a corporation, a juridical person, that was vested with implied powers. And among those powers might well be, I think was, the power to fulfill the purposes for which the government or the corporation was formed. And those purposes are, of course, explicitly enumerated in the preamble of the Constitution. So it's not an argument that the preamble itself vests powers in the government, but it is an argument that the preamble lays out the purposes for which the government was created, and that among the powers vested in the government implicitly by the Constitution is the power to fulfill those purposes. I believe that's the way Wilson and many of the founders actually understood the operation of the document, but it's a longer conversation, as Randy says, going back and forth on the details of this argument.
Thank you. Do Professors Strang and Zuckert care to comment on this debate, or would you like to comment on something else? Professor Strang, I think.
I'll comment on something else. Unless...
Well, it's...
I would say a word or two about this. This is a very big debate between our two colleagues here, and it would take way longer to go into in detail than we have, or at least than I have to give. But I would make 2 points, especially against Professor Mikhail's position. On the one hand, with regard to whether the Constitution, whether the Declaration is in effect our first Constitution, and whether it's in effect carried over into the later versions of the Constitution, as I think he was arguing, I would just raise, I have a bunch of points, but I'll raise one right now, which is if any one of the states or any group of the states had failed to ratify the Constitution, they would not have been part of the Constitution. And therefore, whatever their prior status might have been, it seems to me clear that the ratification of the Constitution changed whatever status they had had before, or that agreeing to it, I think what the real meaning is, they were actually sovereign states who would have been, except for ratifying the Constitution, independent. So that's point one. Another point I would raise that is more complicated than I can go into here is that I think the whole debate about the necessary and proper clause needs to be reconsidered in the light of a debate between Madison and Hamilton over the proper meaning of and way of approaching the necessary and proper clause. And at least in my reading of it, which I'm going to withhold from you, I think Madison has the better of the argument. That is, he pays better attention to the text, and he pays better attention to what they were attempting to accomplish in the government, and that the warnings that Madison and Jefferson, I think Madison is far more sensible on this than Jefferson, but the warnings that they raised about the Hamiltonian reading of the necessary and proper clause were indeed captured the consensus of the people who wrote the Constitution, people who ratified the Constitution, of what kind of government they were attempting to establish, that it's not one with such expansive implications as Hamilton could draw, or Professor Mikhail.
My question was going to be for Professor Barnett. And Professor Barnett, one of the things that you argued was that the reason why the Declaration is central in some ways because it was officially adopted by the Continental Congress. And I wanted to see what your thoughts were on how that is related to the Supremacy Clause. So the Congress, under the Constitution, under our current Constitution, when it went into effect, it went through the previous legislation by the Continental Congress and decided to readopt some of those provisions and then didn't readopt some of the other ones. For example, the Northwest Ordinance, which had been adopted by the Second Continental Congress, was readopted by our Congress under the current Constitution, and in doing so, that first Congress said that the Northwest Ordinance had to be readopted, quote, In order that the Northwest Ordinance may continue to have full effect, it's requisite that provision should be made to adapt it to the present Constitution of the United States. And since the Declaration was never readopted by our current Congress under the Constitution and the Supremacy Clause, why doesn't the Supremacy Clause preclude the Declaration from having official status today?
That's an interesting question. I actually hadn't thought of it before. Isn't the Declaration in the U.S. Code? And why? How did it get in the U.S. Code?
Because in 1926, Congress passed a statute requiring the permanent and general laws of the U.S. to be put in the U.S. Code, and then in Section 2 had a list of, quote, ancillary documents, and one of the ancillary documents, including the articles, was the Declaration. So it's identified as an ancillary document.
Well, that's fine. I mean, first of all, it is in the U.S. Code. Congress did do that, and it is an ancillary document. So I don't think that's an inaccurate description of it. The question is, what is its purpose? What purpose can it serve today? And I basically tried to preemptively agree with you that it's, which is now becoming more difficult, that the original public meaning of the text of the Constitution needs to be interpreted in and of itself, as does the original public meaning of the Declaration, which, for example, does refer to the states in the plural, and they have these powers. I was going to say that also. And so both of these documents have to be given their original public meaning, and I fully agree with you now that I've heard your complete remarks that the Declaration is simply context for what the original public meaning of the text of the Constitution is. But the point of it being, the point I stressed about it being officially adopted is that this is not Randy Barnett's theory. The theory that's enunciated in the Declaration is not Randy Barnett's theory of the Constitution. It is not a libertarian theory of the Constitution. It was the officially adopted American theory of the Constitution. And the fact that it was officially adopted, and John Locke was not officially adopted, Montesquieu was not officially adopted, these other folks were. The word of the public meaning of the Declaration is what was officially adopted, and I cite that as authority greater than myself for why it is. Those are the rights retained by the people. Those are the unalienable rights retained by the people, and I would say is relevant context, for example, to how you would interpret the Ninth Amendment, which refers to the rights retained by the people.
We're not under attack by a screen acting out of its own volition. We're going to see a video momentarily. Professor Barnett will introduce, but any final thoughts? We could talk about this stuff all weekend, but
I just want to make one brief point, if I could, just to try to make the discussion between Professor Barnett and Zuckert and myself a little bit more concrete. When I talk about unenumerated or implied government powers, I have specific concrete things in mind. So, for example, nowhere in the Constitution is the government expressly given the power to own property, or to sue or be sued, or to enter into contracts, or to operate under a common seal. All of these things are acts which the government did right off the bat and had been doing before the Constitution was adopted. These are the kinds of implied or incidental powers that any corporation, which in the 18th century sense of a corporation, which might include a church or the states themselves or the national government, were thought to have without having to enumerate them. And so there are such powers. It's a mistake to take too literally the slogan that this is a government of limited and enumerated powers, if what we mean by that is that only enumerated powers are permitted. I don't think that's an accurate characterization of our government. I do believe, on the other hand, that it's accurate to say that Congress is a government, is a legislature of limited and enumerated powers, so that Congress can only act if it has been given an enumerated power. But one of those powers is the necessary and proper clause, which then opens the door to the exercise of implied government powers. It's a little bit complicated, I understand. I recognize that, but I do believe that's the way the founders understood the document.
all right, people have now lined up, but I think we're going to have to keep moving. We started late. Professor Barnett's going to introduce the video. Perhaps those at the microphones might be able to engage the panelists outside after this, hopefully, if the panelists might indulge them. Professor Barnett.
Yes, I wanted to take this opportunity to tell you while you're gathered here about the Originalism Summer Seminar that we hold here in May every year. Many of you probably know about this. You got an email from National Federalist Society about it. Unfortunately, for this year, we have now accepted all our applicants, but many of you are going to be eligible to apply for it in the future. So rather than talk about it myself and possibly choke while I'm doing so, I will just show you this video, and then I will add one important additional piece of information that's not in the video.
I had a friend who did this last year and really enjoyed it. Just seeing the lineup of speakers started to really attract my attention.
I've really been looking forward to learning more, taking a deeper dive into originalism and just learning all the intricacies of it.
I'd always been interested in originalism as a judicial philosophy, and I really wanted to know kind of the nitty-gritty of what it was as a theory. So that was my hope in this boot camp.
We've decided to... I'm cursed, somebody said from the audience. I think that's probably a fair assessment.
I meant to give the disclaimer that
I had a friend who did this last year and really enjoyed it. Just seeing the lineup of speakers started to really attract my attention.
I've really been looking forward to learning more, taking a deeper dive into originalism and just learning all the intricacies of it.
I'd always been interested in originalism as a judicial philosophy, and I really wanted to know kind of the nitty-gritty of what it was as a theory. So that was my hope in this boot camp.
Well, let's just listen to it. We've decided to try to recruit some of the best law students from around the country to come to Georgetown and be exposed to the cutting-edge, state-of-the-art. That's not me talking. To what originalism is and how it should best be practiced.
I definitely didn't really know what originalism was ahead of time, and just getting to hear from so many different originalism positions, not just one vein of originalism.
But it's way thicker and way more rich than I thought. I mean, there's competing theories.
This is bizarre.
This
is absolutely bizarre. You know what?
Originalism is. There's competing theories about what to do with originalism.
All right,
I'm someone who's interested in strategic litigation and appellate litigation. That is particularly why
I've had it. I've absolutely had it. This is it.
To use originalism.
You should go to our website and watch. It's a great program. We have many fine judges who are speaking at the program. We go to the Supreme Court. We visit with justices there. Last year we visited with 3 justices. This year we'll visit with 2. And the final piece of information that isn't in the video, which I will add, is that there is a $3,000 honorarium for those of you who will take a week of your time to spend it with us here at Georgetown Law. So I apologize for the technical difficulties. This has been a complete and total disaster as far as I'm concerned from beginning to end. But at least I enjoyed the remarks that my co-panelists made today. Thank you.
I'll just make, in Professor Barnett's defense, I'll make a big disclaimer. I happen to be the chair of the Judicial Conference's IT committee. We meet twice a year, and without fail, at our meetings, there is always some glitch in the technology. So this is not unique. But also, the disclaimer is that I had nothing to do with putting so many Georgetown and Notre Dame people on this panel. And please join me in thanking our panelists.